So hello, everybody. I'm Beth Rebay, the host of the Civics Project and the director of Repair, which sponsors the Civics Project. Welcome to our episode today on the right to privacy. I invite folks to join us next week at this same time, Sunday, October 10th at 2 o'clock Pacific, 5 o'clock Eastern time for our upcoming episode on higher education. You will find the registration page link both in your confirmation for this event if you're joining us live in Zoom, or in the podcast description if you're listening on Google or Apple or Spotify or another podcast hosting platform. I want to begin today with a brief land acknowledgement before we get to the primary content. So Repair acknowledges the Gabrielina Tongva peoples as the traditional land caretakers of Tabangar, the Los Angeles Basin and South China Islands. And we are grateful to have the opportunity to work for the Tarahatom, the indigenous peoples in this place. We pay our respects to Hanukvatam, the ancestors, Ahihiram, the elders, and Eohinkem, our relatives and relations, past, present, and emerging. So, as noted, our episode today focuses on the right to privacy. And I'd like to talk a little bit about its history and context. So you will never find a reference to the word privacy in the Bill of Rights, for instance, or elsewhere in the Constitution, especially in the way that we think of it today. So privacy rights, as we think of them now, are never explicitly supported by the Constitution as it's written. The first Supreme Court justice to think about the issue and publish something about it was Justice Louis Brandeis, and this was before his appointment to the Supreme Court. He co-authored an article which was published in the Harvard Law Review titled "The Right to Privacy," and started to lay out what he thought the foundations would or should be for such a right, and to sort of try to ground it in existing constitutional law. But this, again, was an academic article before he served on the Supreme Court. So until basically the 1960s, the United States existed without a constitutional right to privacy. Now, as many of you know, just because the Constitution doesn't say something doesn't mean that a state or the US Congress or even a local municipality couldn't create some protections, for instance, for privacy. So that didn't mean there was no such thing as privacy law anywhere, but without a foundation in the Constitution, it wasn't something that had to be applied consistently to all of the US states. So the first time that the question of privacy was more definitively decided by the Supreme Court was in 1965 in a case called Griswold versus Connecticut. So this is what was happening. The case had originated in 1961 and was decided by the Supreme Court 4 years later. And the plaintiff, or the appellant in this instance, was a woman named Estelle Griswold. And she, in the 1960s, was the director of Planned Parenthood Connecticut. She, in partnership with a Yale School of Medicine gynecologist named C. Lee Buxton, opened a birth control clinic. Now, Connecticut at the time as a state had a statute which had been in place for more than 80 years, since 1879. And this state statute made it a crime to use contraception. So it was illegal to use contraception in 1961 in the state of Connecticut based on a 19th century statute. So the reason that Estelle Griswold and her partner, in this case, literally her partner in crime, C. Lee Buxton, were arrested was that through the work of their birth control clinic, they've been giving married couples birth control information and medical advice, and had also prescribed contraception. And the state of Connecticut found that all three of those activities, giving information, giving advice, and prescribing contraception, made Estelle Griswold and C. Lee Buxton accessories to the crimes of their patients who then would take contraception. So they were prosecuted as accessories to the crime, and they challenged this prosecution on constitutional grounds. So Estelle Griswold particularly initiated this suit and advanced it ultimately through appeals all the way to the Supreme Court. And her attorneys argued that the 1879 Connecticut law, which prohibited contraception in this case, was violating the 14th Amendment to the Constitution. Now, the relevant part of the 14th Amendment is Section 1, which first of all tells us who's a citizen, anyone who's born and naturalized, and then tells us that the government won't take away certain rights from citizens, and then establishes what we know of as the equal protection and due process clauses, both of which are intended to protect life, liberty, and property. So the state may not take away anyone's life, anyone's liberty, or anyone's property without due process of law, nor can it treat people in ways that are discriminatory. And that is bound up in the clause that reads, nor deny to any person within its jurisdiction the equal protection of the laws. So Griswold conceivably could have made a number of arguments just using those two clauses, equal protection and due process, and also could make an argument about, in general, that no state can enforce any law which abridges the privileges or immunities of citizens. So the married couples who Griswold was generally prescribing or giving medical advice and counseling to, and that her partner, C. Buxton, was giving prescriptions to, were generally speaking in Connecticut at that time, US citizens. I don't know if there were any exceptions, but for the most part, that was not in question by the court. And so the question that Griswold posed is this Connecticut law in violation of the 14th Amendment? She argued that it was. She said essentially, first of all, citizens have a right to privacy, and that should be one of the privileges you have as a citizen, and states can't make laws that will keep people from having confidential conversations with their doctors. And a second argument that can be made under the 14th Amendment is that if you are interfering with people's access to their health care, that's depriving them to some extent of liberty. One could even try, I don't think Griswold did, but one could try to make an argument about life, arguing that if you are preventing people's access to contraception, you increase their risk of death in childbirth. You could also make an equal protection argument under the 14th Amendment, essentially saying that a lack of access to contraception poses an undue burden for women because of the risk of getting pregnant. So Griswold tried some amalgam along with her attorneys of these arguments and argued basically the 14th Amendment should make this Connecticut law illegal because people have a right as people and as citizens to privacy. And again, she had to make that case without the Constitution ever mentioning privacy. So she had to be able to persuade the court that it was implicitly bound up in the Constitution. So what the court actually did in the Griswold case in 1965 was basically a win for Griswold, but not in the way that she had asked for. So they did find that her arrest was unconstitutional. They struck down the Connecticut statute. And they agreed that there was a privacy right bound up in the Constitution. But they didn't decide that it was related to the 14th Amendment. So basically what they determined was that she had a privacy right on other bases. And the bases that the court looked to were bound up in other areas of the law. They looked at, for instance, the First Amendment, and so the First Amendment gives freedom of association, for which people would need some privacy. So we could arguably say that that privacy is supported by the First Amendment. The Third Amendment says that you can't just have, during peacetime, the military come and quarter their soldiers in your house. And so the court said, well, we think that means that people generally accept it under these extraordinary circumstances have a right to privacy in their homes, right? If the state can't just invade your house, it protects your privacy. So they said, even though the Third Amendment doesn't talk about privacy, we think it's supported there. They got to the Fourth Amendment and they said, yeah, unlawful search and seizure, that means that if you can't just be searched at random by the state, then obviously you've got some rights to privacy implicated in the Fourth Amendment. They even went to the Fifth Amendment, which protects people from having to share information that would incriminate themselves. And they said, okay, so people have a right to keep some information private from the state. And they said, collectively, these are all adding up to areas of privacy that the state can't infringe upon. And they also looked to the Ninth Amendment, which is a broad statement basically that says whether or not the Constitution talks about a right or not, it belongs to the people unless the Constitution indicates otherwise, right? So people have rights, even if the Constitution does not explicitly protect them, unless the Constitution takes that away. So that certainly lends itself to, making the claim that between the First, Third, Fourth, and Fifth Amendment, privacy was implicated, and even absent its explicit reference, as indicated by the Ninth Amendment, it should be assumed to belong to the people. So the court came to this complicated analysis, and they used the term penumbra, which basically means something that's in the shadow of or under the umbrella of something. So they said that the First, Third, Fourth, and Fifth Amendments created a penumbra, a sort of shelter or framework through which privacy could be understood. And interestingly, what they didn't do is agree with Griswold that the 14th Amendment also implicated a right to privacy. So they basically said, we're not buying your argument about why this statute is unlawful or why privacy is constitutional, but we're going to get to the analysis a different way. So Griswold won. They struck down the statute. They found a constitutional argument for the right to privacy, but they didn't explicitly indicate that the 14th Amendment protects privacy. And we can only speculate to some extent about why this was important to the 1965 Supreme Court. However, the majority opinion, which was authored by Justice Douglas, basically talked through this argument about why the Connecticut statute did violate a privacy, why that privacy right was constitutionally protected, and on what grounds. Justice Harland filed a concurrence. So for anyone who's not familiar, when the majority of a Supreme Court decides something that's written up as a majority in opinion, a concurrence is when one or more of the justices decide that they have something extra to say that the majority didn't agree with, although they agree with the overall majority opinion. So it's basically like, yes, I agree, and also, right? So a concurrence was filed by Justice Harlan with, I believe, a couple of his colleagues. And the Harlan concurrence made the case to say that, as Griswold had argued, the 14th Amendment also provided a right to privacy. So this concurrence, right, I agree with the finding of the court, and I add something else, was where Justice Harlan said, yeah, there's 14th Amendment protection for the right to privacy. Now, a question you might ask is, why does this matter, right? If they found for Griswold anyway, who cares which amendments they used? And an answer is that the terrain of the right to privacy is, if it's only based on the First, Third, Fourth, and Fifth Amendment, it's going to be limited to the areas that those amendments cover: the right to association, the right to one's home, the right to not incriminate yourself, the right to not be subjected to unlawful search and seizure. But it will leave open the question of, does this law, generally violate a broader right to privacy, which could exist in other spheres? Now, the way that the Supreme Court located the right to privacy in the Griswold decision was they basically said, well, the right of a married couple to have privacy about sexuality and reproduction, that's clearly so intimate. So one thing that was important in the Griswold decision was that they were basically saying, like, this violates the privacy of a married couple. They should be able to, talk about sex and reproduction and make decisions about it without the state looking in. And then they located the fact that marriage was, clearly part of the home. And so they could kind of connect that to the Third Amendment right to have privacy in your home, right? But it didn't mean that reproductive decisions generally would be understood as private under the Griswold decision. It meant married couples should not have their privacy relative to contraception violated. So one thing the 1965 court was likely trying to do was to say, well, we're going to establish a privacy right. We're going to connect it to this particular Connecticut statute and say the statute goes so far, but we're not ready to say that there's a broader privacy right, period, for anything, or a broader privacy right for contraception anywhere, anytime, right? They were limiting this to married couples and their doctors, or to any other kind of reproduction. So they created a privacy right, but they kept it pretty finite and left it for other courts to think about. So when Justice Harlan was filing his concurrence, he was saying the court came to the right decision on Griswold's challenge, but they didn't go far enough. We do need this broader, wider right to privacy. So Justice Harlan gets the credit for basically, in a major Supreme Court decision, first articulating that framework. And this was in 1965 when the case was decided. So after this period, there were three major decisions that basically extended the right to privacy. So they took what the Griswold decision had done and they took it further. So Eisenstadt versus Baird was decided 6 years later in 1971. And the Eisenstadt Supreme Court decision basically said that the right of privacy doesn't just belong to married couples. It belongs to individuals. Individuals have a right to privacy. And it also affirmed that married couples have a right to purchase and pursue contraceptives. So like the Griswold decision, it dealt with contraception, but it said it's not just because the invasion of privacy in the original 1965 Connecticut statute was basically deemed to go too far because it was invading marriage. So the Eisenstadt decision goes farther. And they basically took Justice Harlan's framework and said yes to it. So they said, as of 1971, there is a right to privacy that belongs to individuals, and it is vested in the 14th Amendment, right? It's a liberty interest. It's a potentially an equal protection interest. It's a due process interest. So 1971, the Eisenstadt case says, not only is there a right to privacy in the Constitution as indicated by the Griswold decision, but individuals, not just married couples, have that right. And not surprisingly, just a year later, Roe versus Wade was decided. And what this case basically added to the right to privacy was, first of all, it went beyond the realm of contraception and dealt with abortion. And it also said that the 14th Amendment clauses dealing with personal liberty and restrictions upon state action extend to privacy. So it added even more content to say, yeah, at least two sections of the 14th Amendment support a right to privacy belonging to individuals. And the Roe versus Wade facts also made clear this is not just about contraception or other sorts of matters. Privacy can protect a conversation a woman has with her doctor about abortion. So this is Roe versus Wade, 72, 7 years after the Griswold decision. 2003, the last major landmark around privacy rights comes up in Lawrence versus Texas, right? So now we are a good 38 years after the original Griswold decision. We're into the new millennium, and Lawrence versus Texas comes up, and it challenges the Texas criminal law. We have a lot of Texas criminal laws coming to bear, just like Roe versus Wade, but this one bans sodomy. So it basically bans same-sex sexual activity between men. And the Texas sodomy law had also sometimes been applied to women without getting graphic, around oral sex. So we've got this law in Lawrence versus Texas that had been used for some years in Texas to criminalize homosexual or same-sex sexual activity. And the Lawrence versus Texas decision, again, figures out, do these 14th Amendment privacy rights apply here? And they say, yes, they do. The government should stay out of people's private sexual lives, right? If we're talking about consenting adults, the government just needs to back off. And that was the thrust of the Lawrence versus Texas decision. And that was decided in 2003. So we've got Griswold, we've got some earlier cases that sort of teased at the issue, but we've got the Griswold case finally definitively saying at the level of the Supreme Court that privacy is a constitutional right, but in a very limited way. Then we've got Eisenstadt saying actually it's grounded in the 14th Amendment and it belongs to individuals. Then we've got Roe versus Wade saying not only that, but the 14th Amendment strongly protects the right to privacy, both by restricting what the state can do to people and as a protection of personal liberty. And then we've got Lawrence versus Texas saying it's not just about birth or reproduction, it's just about sex, period. And saying people get to have private sexual lives and the state needs to stay out of it. There still would be exceptions, right? So you could still, for instance, restrict things that are not about consent, like rape or like statutory rape, having sex with child or child molestation. So it doesn't mean that everything people do sexually is completely private. You could also have public indecency laws, like you can't have sex, in the middle of a shopping mall while everybody's watching, right? So there's some restrictions that are allowed to be made, but the whole idea is that if this is something that can be private and nobody's rights are being violated, then the state should stay out of it. And that was the gist of the Lawrence versus Texas decision. So part of what remains at stake in the right to privacy today is that it continues to come up in the United States as part of the legal landscape around reproduction and the question of reproductive rights and choices. And there's a tension that I think the courts have acknowledged and that I think our current Supreme Court is very preoccupied with, between the question of, is there a right to life? And if so, who has it? And how does that interact with the right to liberty, which we know is connected to privacy? And in the 14th Amendment is explicit that citizens have rights. Citizens are such on two bases. One, they're naturalized, so they go through an immigration process. Or two, they're born, right? The 14th Amendment is really clear that birth matters. So citizenship under the 14th Amendment does not begin at conception, it begins at birth. But the latter part of the 14th Amendment doesn't say citizens, it says persons. So it leaves this question that the courts can struggle with, which is before a fetus or an infant or a baby, whatever language the various players are using, is born, are they a person in the way contemplated by the 14th Amendment? So advocates against abortion would say life begins at conception, first of all. And the 14th Amendment says you cannot take away anyone's life, right? You have a right to life and the state should not interfere with that. And so it might say, for instance, that now it would still be another bit of a leap for the state to be allowed to protect that right? Because the 14th Amendment says basically it shouldn't deprive anyone of life, liberty, and happiness. But you could at least try to make that argument that maybe not depriving in this case, given the vulnerability of a fetus, would mean active protection. So this would be kind of a anti-abortion argument grounded in the 14th Amendment and focused primarily on the idea of life. And it has a number of legal questions to engage. There's really no argument that before birth, anyone is a citizen. So the argument is a fetus a person? And from those arguing for reproductive rights, choices, or justice, from pro-abortion stances as well, the right in question is liberty, right? So the 14th Amendment says that the state shall not deprive anyone of their liberty without due process and will not also do anything that's discriminatory, which could be argued either based on its impact or on its intention. And the liberty argument here is that to force someone to go through pregnancy and to deliver, right, is taking away their freedom. And certainly in a contemporary context like this, where people are, thinking about, is the government even allowed to force you to get a vaccine? We can think about the stakes in saying the government is allowed to force you to continue a pregnancy for up to 9 months and to go through labor, right? So there's a strong liberty argument here as well. And citizenship protections don't apply to everybody who can get pregnant, right? Not all pregnant people are citizens. So that part of the 14th Amendment wouldn't offer cover to everyone. But again, the question of persons having a right to liberty is a meaningful one in which you could make an argument under the 14th Amendment, in which people have with some success for a while. Now, the trick here is the question of privacy. So because the framework for reproductive rights since Griswold has been about privacy, and that was her strategy, right? She introduced that to the Supreme Court. The Supreme Court started by saying, okay, well, married couples can have privacy. That's protected. The state shouldn't interfere with that. And then the Eisenstadt case extended that and said, okay, individuals have privacy rights too. But one thing that's never been clearly settled is there a clear liberty right simply in not having to be pregnant? Right? So the right people have is to make decisions about reproduction privately. But that's a little different from the state saying you have a right not to be forced to be pregnant. Right? The state has never actually, at the level at least of the highest court, grounded the right to an abortion or any other kind of reproductive technology in having liberty to make that choice. Instead, it's grounded in the state not infringing on your privacy rights, which is more complex. And on the other side, the federal courts, some lower courts have, but the Supreme Court has not, at least since Roe versus Wade, definitively decided or ever clearly stated there is a life interest protected by the Constitution that applies to fetuses, infants, or babies before birth. So right now, privacy is sort of the compromise, which is rapidly thinning, that the courts have held to not quite ever choose between these questions of life and liberty, which are implicated in the 14th Amendment and questions of reproduction. So we get to today, and most of you have been following or are familiar with the fact that the Texas Heartbeat Act was just passed this fall. And the act essentially, practically speaking, bans abortions after 6 weeks. And it does something unusual. It gives private citizens the right to sue anybody who is actually taking steps or even is intending, which is a really interesting argument legally, that you could sue someone for their intention. But establishing that someone basically is aiding, abetting, or trying to aid or abet an abortion allows you to sue them for up to $10,000. And this right doesn't belong to the state. The state isn't the one initiating the lawsuit. Instead, it says anyone who can be from another state, who can have nothing to do with any of the parties, can initiate one of these lawsuits. One of the reasons the Texas Heartbeat Act was written in this way was because the Texas lawmakers at least are trying to argue the state isn't going to stop you from having an abortion. The state is just allowing other people to sue you. It's sort of a tricky game, right? So the state will allow private people to sue anyone who is facilitating abortion. And the state of Texas, at least those that passed this act, would argue this doesn't violate the 14th Amendment because the state isn't the one taking action. Instead, private people are. Again, I think that's a tenuous argument, and it will be interesting to see what happens with it in the courts. But it tries to get around the question of the state infringing on your liberty or due process by having third parties be the ones who are sort of taking away a freedom. And the Texas Act also basically is, not quite resolving the question. I mean, it's very clear that its authors see an interest in the right to life as something the Constitution should protect, but it's not quite resolving all related questions. It's sort of in and of itself a workaround that says, we'll get around these privacy protections by finding a third party that can violate the liberty interests the courts have recognized before. As we also know, the Texas Heartbeat Act was brought before the Supreme Court, and they said, yeah, we won't give you any injunctive relief. It goes into effect now, and we won't hear it until it comes back to us potentially. So, and this was a 5-4 decision. So the progressive justices on the court dissented. So did Chief Justice John Roberts, who is known to be pretty conservative and not a friend to abortion rights advocates. But Justice Roberts made the case that the unusual part of the act, the fact that they were sort of giving enforcement powers to anyone, not to the state, was such that the court should deliberate that, and he was basically saying, like, let's figure out what we're going to do to overturn Roe versus Wade some other way. Let's not just, enable this when it's doing something that we don't even know is like viable legally, which is to give private enforcement powers that would normally belong to the state to individuals. Right. So Justice Roberts here was trying to take a more traditional approach, and he was overruled by his other colleagues. We've often heard there's a 6-3 majority on the Supreme Court, and 6 of them, those 6 include John Roberts, but he's also someone who I think is very concerned with the dignity and tradition and legitimacy of the court. And so he doesn't want his court to be perceived as spinning off in some radical or extreme direction. And his concern here was that this law was sort of too outlandish, and he would rather sort of revisit Roe versus Wade through some more conventional means. And again, his counterparts disagreed with him, so the Texas Heartbeat Act has effectively gone into practice. It is in practice now in Texas, and as some of you know, our Department of Justice has been trying to figure out what to do with it. I want to make one more note about the socio-legal landscape, and that's just to understand that the impact of restrictions to reproductive care is not evenly distributed, and that also raises some equal protection questions. So, and here I'm not just referring to the fact that only girls or women or people who menstruate, as some of our elected representatives who have referred to it, can get pregnant. The issue is also that state by state boundaries, which vary. So you can get an abortion in one state, but not in another. These kinds of restrictions have disparate effect on people who are low income. And disproportionately, those are women and girls of color. People with existing children who can't easily hop on a plane and get out of state. And so one of the issues that reproductive justice advocates have been raising in all of this is understanding that, for people who have the wealth, state level barriers to accessing reproductive care don't really matter, because you can always just fly either to another state or another country and get what you want. So one of the arguments that's also coming up is that these kinds of laws are likely to have disproportionate impact on people who are already low income and therefore may be less prepared to carry an unwanted pregnancy. Now, for those who'd like to read more in that vein, my book recommendation for this week is the text Reproductive Justice: An Introduction, and that's authored by Loretta Ross and Ricky Solinger, both considered leaders in the reproductive justice movement. So I'm going to go ahead, for those in our Zoom, and put that in the chat if our Zoom will cooperate with me, and it seems not to be. Sorry, we're having technical glitches. But again, that text is Reproductive Justice and Introduction by Loretta Ross and Ricky Solinger. And again, I want to invite everyone to join us next week for our next episode on higher education. Got it.